Thank you, Chairman. Members of the committee, Susan Myers of the 20th, here in support of SB 363. Every CCW class, armed church security team member training, or other firearms personal defense classes I've ever been through goes over what to do if you are involved in a self-defense shooting. First on the list, once it's safe to do so, is to call 911 to report the shooting and request police and ambulance. Failure to report a shooting is a crime, yet doing so compels self-incrimination into the mix. Then add to that the fact that it being incumbent upon you to prove your actions were justified. Someone claiming self-defense should be given the opportunity to do so prior to a trial getting underway, potentially sparing them months of unnecessary anguish, damage to reputation, and legal expenses should the judge agree. This would not be an automatic slam dunk. The court would assess whether the state has probable cause to believe the defendant's use of force was not justified, considering both the prosecution's and the defense's evidence equally without favoring the state. How is that too much to ask? Some opposed to the bill argued that in a hypothetical case with no witnesses or obvious evidence, anyone can claim self-defense, insinuating people will get away with murder. I feel compelled to ask about the flip side of that. Under current law, how many have been wrongfully convicted because of a lack of exculpatory evidence to back up their story? A lack of evidence doesn't change the fact that they may truly be innocent. There are bipartisan bills in both the Senate and the House that seek to address wrongful convictions. I would think the supporters of those bills, of which I am one, would support this bill as well, as it affirms the fundamental principle of innocent until proven guilty. Thank you.